So you've made it all the way through litigation, and now it's time for trial. I'm Chase Elleby. This is Jared Easter. We are attorneys here at Williams, Elleby, Howard, and Easter, and today we're going to talk to you about the trial process and sort of a basic timeline of how things take place. So as always, in the description, we'll have resources for you guys, so please feel free to click on that, like, subscribe, all that fun stuff, comment if you have any questions. All right, let's jump right in. Jared, we've made it to trial. First of all, is it common to go to trial?
It is not. Most cases generally settle before trial through various means, but generally speaking, I would say probably more than 80% of our cases, maybe even more like 90, settle before trial or literally right before. So you might get just to the courthouse and settle it on the way in the door, but generally it is not super common for your case to end up at trial.
Yeah, it's way more common for your case to get like all but to trial, because that's when really the insurance companies start to take notice, start to pay attention and say, oh, dang, we're about to go to trial now. Let's really try to get this case resolved. So yeah, to Jared's point, it's not very often that we go to trial, but we always posture every one of our cases like we are ready to go to trial, because that's how you get maximum value on cases, because trials are, in some regards, the wild, wild west. So we're not going to talk specifically about, the trials themselves, but more, again, the process. So, all right, we can't get the case resolved. We're going to trial. What's sort of the first thing that you do when you go to the courthouse?
First thing you do is going to generally be jury selection, or voir dire. That's where you get a panel of jurors who are made up of people in the county who are registered voters. They come down to the courthouse. Everybody's heard about, I got jury duty. You come down, the jurors will fill out some information, some forms that we'll get, and then we'll get a certain number, generally about 43 to 50, maybe more, depending on how many jurors are available to pick from. And that's step one, is to pick the jury.
Right. So they pretty much get just kind of pulled into the courtroom. You get, you sit down on a bench. Some courthouses will give you like a paddle and things like that, and the lawyers will have an opportunity to ask the potential jurors just questions, right? Questions about not necessarily the case or the facts, but questions about any leanings they might have. And the job of the lawyer is to determine which jurors they want to strike. So it's a common misconception that lawyers get to pick the jury. They don't get to pick the jury. They basically get to strike who they don't want on the jury. We don't get to select, the 42 or 50 or however many folks that are coming in to be questioned. We just get to cross out the ones that we don't want, that we think might be bad for our case. So
then we end up with what's left over.
Right.
That is how you pick a jury.
Right. So that is jury selection. And if you happen to get picked on a jury and you are the 13th or 14th juror, you are going to be an alternate. So you're going to sit in that trial and you're going to listen to the case. You're going to think you're going to be in deliberations, but at the very end, the judge is going to pull that rug out from under you and say, hey, alternate, you have to go to a separate room while the 12 people sit and deliberate. Thank you for your service. Anyway, that's just a little helpful tip if you happen to get called for jury. So you pick the jury gets impaneled. Judge usually goes over kind of the rules. They all get sworn in, all that type of stuff. And then I guess it's time for the show. So what happens next?
Well, then the trial begins. The plaintiff goes first. The person bringing the case goes first to present their case, and that generally starts with an opening statement. An opening statement is just kind of a preview of what's to come, where the lawyers will tell the jury, what to expect, what the evidence will be coming in, and really just putting your case out for the jury to see.
Right. So in opening statements, the plaintiff gets to go first. And then right after that, the defense gets to get up and give their opening statement, right? They get to tell the jury how they see the case, what the evidence is going to show in their favor, and things like that. And then once opening statements are done, it goes back to the plaintiff's turn. So the plaintiff will call and swear in their first witness. So if I'm the plaintiff's lawyer and Jared's my client, I'm going to call him in. He's going to get sworn in. And then I'm going to start asking him, as the plaintiff's lawyer, as my witness, I have to ask him direct questions, right? What's your name? Where are you from? Tell me about the wreck. Okay, I can't ask leading questions like, is it true that you didn't run the red light? Is it true you didn't, make a right-hand turn? Whatever it might be. And through the witnesses, me as the plaintiff's lawyer will be able to admit certain evidence, right? So again, if it's a run-of-the-mill car wreck case, that's how I, get the medical records and the medical bills in. Jared, these are medical bills, or these are medical records. Once I'm done with a witness, the defense can then get up and ask Jared questions while he's still on the stand, and they can do their cross-examination of the witness, okay? So that includes the Well, it's true you hurt your back last year. Let me show you your medical record. Isn't it true that you had surgery on your leg before this wreck occurred? So that's when the cross-examining gets up. So the plaintiff gets to do that, gets to go first, put all their witnesses up, and it could be, again, depending on the case, it could be just, if it's a car wreck case, it's going to be the driver, it's going to be the defendant. I can call, as the plaintiffs in my case in chief, I can call the defendant up to the stand on cross-examination because they're an adverse witness, meaning they're not my witness, so I can cross-examine them there. Then once the plaintiff side gets through all their witnesses, admits all their evidence, they rest or close their case, okay? That's the opportunity then for the defendant. If we don't think, or if the defense attorney doesn't think we got in the evidence we need, what's the defense going to try to do?
You're going to move for a directed verdict and basically ask the judge to essentially dismiss the case or throw it out, direct a verdict in favor of the defense, because they'll argue that we didn't meet our burden of proof with the evidence to kind of check the boxes, so to speak, to prove our case.
Right. A good example, just a real kind of elementary example of that would be, like, let's say in the plaintiff's case, I put Jared on the stand and I don't ask Jared, how he got hurt or if his injuries were related to the car wreck. Well, then when I close my case, the defense can get up and say, Judge, I'm going to move for a directed verdict. There's no evidence to prove that these injuries were caused by this wreck. So that's one way that you could do a directed verdict. So most of the time in a simple case, the other side won't usually move for directed verdict. In more complicated cases, they will. And so assuming you get past directed verdict, what happens next?
So then the defense essentially gets the same opportunity the plaintiff had to put on its case if it wants to call any witnesses. Same thing happens, but reversed. The defense would be directing its witnesses. The defense attorney can call their client. They can call experts they might have hired to come in to try to undercut the plaintiff's case, to argue that the injuries weren't related, crash recon guy, all of those sorts of things. The defense directs their witnesses, and after each witness, the plaintiff then gets the chance to cross-examine that witness, try to challenge the testimony, look for inconsistencies, poke holes, as Chase discussed earlier. And then essentially after that, the defense finishes up and they rest.
Yeah, and you bring up a good point. The first thing you said is if the defense wants to, right? The defense doesn't have to put on any evidence at all in a civil case, right? In a civil case, it's always the plaintiff's burden, meaning the plaintiff is the one that has to prove the case. And a lot of times, especially if it's a kind of a standard, simple car wreck, you're going to go try that case, and the thing you're only really going to be arguing is the damages, right? Whether the wreck caused the damages, the injuries, and how much those damages are worth. You're usually not arguing about what happens, and it's a common tactic for defense attorneys to not put on any evidence at all, right? They will just try to, in the plaintiff's case in chief, they'll just try to poke holes in their cross-examination of the witnesses, and then when it becomes time for them to put on evidence, they'll say, Judge, the defense rests, we're not putting on any evidence. Now, the strategy for doing that is defense attorneys want to do what we call stealing close, okay? That's just a kind of a legalese that basically says that when it's time to close the case, meaning give your final argument, if the defense hasn't put on any evidence, they can be the last ones to speak. Some say it's way more advantageous to be the last one to speak. Some say it doesn't matter. I mean, if you got a good case, you got a good case. Who cares if you talk last? I mean, there's all these jury focus groups and things like that that'll tell you jurors usually make up their mind in the first hour of a case anyway. But it is, again, it's a strategy where defense lawyers won't put on any evidence so they can be the last ones to speak. So once the defense rests, then typically you have what's called a charge conference. That's when the jury goes away and the lawyers go and talk with the judge about what the charges are going to be to the jury. So what are the charges? What does that even mean?
The charges are the rules, the way the jury needs to decide the case. The charges, it's basically like reading the instructions when you start playing a board game.
Right.
The judge will, which I've always thought is crazy, literally read them to you. Mm-hmm. They will charge the jury, and that means you will sit and listen to pages and pages of readings of what the law is. He or she will give you definitions about what pain and suffering is, what causation is, the burden of proof, and whether, how to decide whether the plaintiff meets the burden or not. Each case has a lot of law involved, and the way you as the jury learn that is through the charge conference, with the judge literally reading you the law and making sure you at least hear and hopefully understand how you should employ the law to make a decision in the case.
Right. So if you're a juror, just know that the judge is the one that gives you the law. The lawyers are the one that give you the facts. And as a juror, you're supposed to take those facts and morph them with the law that the judge gives you to come to your decision. And so, so the charge conference, and the reason why the lawyers have the charge conference is because before the case even starts, the judge asks the lawyers to submit their proposed jury charges, right? Meaning the judge says, hey, plaintiff lawyer, defense lawyer, go ahead and send me what you're going to ask me to charge the jury on, meaning what law you want me to read to the jury when they're deciding this case. And so what we give the judge before trial even happens doesn't necessarily mean that the judge is going to read it once the trial is done, because we have to put in evidence to allow the judge to read whatever that charge might be. So that's why we have the charge conference, because we have to talk with the judge and say, okay, judge, plaintiffs initially submitted jury charges 1 through 10. We're going to take out 7 and 8 because we didn't talk about it. We're dropping those claims anyway, so let's take those out. Or the defense might, say, well, we want to take out 10 because we think it's bad law, or whatever it might be. So then you kind of have the argument on what the charges are going to be read to the jury. Once that's done, the judge gets everything, and like what Jared said, gets it all nice and orderly, and quite literally sits there and reads the charges to the jury. About halfway through that's when most of the jurors are like, okay, let's get to it.
It's like long, tedious read.
Juries are smart. They get it. They understand what's going on. So it's kind of like you can tell they're like, all right, let's go. Let's get to the good stuff. So you do the charge conference, then you do the closing arguments. And the reason you have the charge conference before the closing arguments is because as the lawyer giving the close, you kind of want to know what the jury's going to be considering anyway. Mm-hmm. And a lot of times we'll use the jury charges as sort of part of the argument that we're arguing to the jury, right? One of the classic charges is what is pain and suffering. Pain and suffering is the enlightened conscience of a jury, but there's certain elements that the jury can consider. So we use those charges to talk to the jury about, okay, when you're back there talking about pain and suffering, here's what you consider, this, that, and the other. So
you want to make sure when that 30 to 45 minutes of reading is going on, we pull out the ones we want the jury to focus on. We can talk about them and close, because there's a better than average chance people are tuned out by the time you get to charge number 13, which happens to be the important ones.
Right, exactly. So then the plaintiff will go first, and given their closing, the plaintiff can reserve time, right? So if the defense has put on evidence, the plaintiff can say, I'll take first close and last close. So a lot of times what will happen is the plaintiff will get up and sort of talk about, what happened in the case, right? If it's a car wreck, talk about the car wreck, how you heard evidence that it was terrible, you heard evidence that, my client had to go to the doctor, you heard evidence about the surgery. I'm going to let the defense talk, and when they're done talking, I'm going to get up and tell you what I'm going to ask you to do, right? So then the plaintiff will sit down, the defendant will get up, and the defendant's their close is going to try to just basically keep the verdict down or say don't give them anything. And then once they're done, the plaintiff gets back up, finishes up, and then that's pretty much it as far as the argument and everything goes. Did I miss anything?
Nope. Usually in that either first close or last close, if we get it, that's when we actually ask the jury to award a number.
Right.
And, that's the common phrase of, what are you suing for? That's the point in time where you finally tell the jury, like, hey, you've seen all this evidence. This is what we think the case is worth. This is what we're asking you to do.
Right. Yeah, so then once that's done, the judge will again read some sort of rules, a handful of rules to the jury. The jury goes back and they wait in their deliberation room while the lawyers look over the exhibits that are going to go back with the jury, and then the jury deliberates. Sometimes deliberations are quick, sometimes they take a long time. That's sort of the fun, exciting, and stressful part while you're waiting to see what is going to happen. And then once the jury deliberates, they reach their verdict. You might have some post-verdict motions depending on how the case went, and then you're pretty much done.
Yeah,
is that pretty much it?
Pretty much covered it.
So yeah, go try cases. They're fun. No, but in all seriousness, there's a lot of work that goes into trying cases. Even the sort of what we call the kind of standard cases take a lot of work just to get everything organized and ready to present to a jury in a clear, clean, concise way, because juries don't want to be there. They're taking time out of their day. They're not getting paid. And if they are getting paid, let me take that back. They're definitely getting paid, but they're getting paid much less in most cases than what they would be getting paid had they been, not in sitting in a jury. So lawyers are very aware of that. We try to get through cases as quickly as possible. And yeah, I don't know. Did we pretty much hit everything though?
I think we did.
All right. Well, like I said, we will have some resources in the description below. If you guys have thought this video is helpful, please like and share, tell your friends about this channel, and we will see you next week.
As personal injury lawyers, we love what we do, and we're happy to share the experience we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when you're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.